What are we doing on this?
Your Honor, today's the date comes up for preliminary examination. At this time, people are unable to proceed as to count 1. It would ask that count 2 be remanded to district court.
To dismiss.
I would move to dismiss count 1.
People being unable to proceed on count 1. That charge is dismissed. I'll continue to defendant's not guilty plea as to count 2. Set this matter for pre-trial before Judge Barr on
June 18th.
And you're
June 18th, 2025, 10 a.m. before Judge Barr.
if I may address bond.
You may.
Your Honor, the serious felony is dismissed in this case. This is actually the second time this matter has been set for a preliminary exam, and complaining witness has failed to show twice. Has another matter set with her tomorrow that's set for final settlement. Based on the trajectory, I'm assuming she's not going to show tomorrow. I'm asking for a reduction in bond. She's got $100 bond in that case. It's actually at 1,010%. I'm asking for something similar to that if it's a 1,010%.
Bless you. Response.
Your Honor, at this time, I'm going to object to modification of bond. This case is set again for examination. I failed to appear for the first exam, and then while he failed to appear, he did pick up bond violations with the same victim. So at this time, I'm going to object, and I think it's something that could be addressed in pre-trial on.
You're right, Your Honor. Regarding that was, I'm a part of that other matter. Mr. Johnson did turn himself in.
He had 2 bond violations.
The allegations are regarding a location over on MacArthur Boulevard. We would not be objecting to anything regarding a tether where he would not be able to go near MacArthur Boulevard.
What I'm indicating is that when he was released on this case, he had 2 bond violations. So he seemingly can't follow direction as to what he's supposed to do and not do. Motion for bond reduction denied. Bonds will continue.
Thank you, Your Honor.
Honor, Robert Ellman with and on behalf of Mr. Phillips, who's approaching. Mr. Phillips, could you please state your name for the record?
William Phillips. Thank you.
Your Honor, today's the date time set for preliminary examination. At this time, if people are unable to proceed as to count 1, it would ask that count 2 be remanded to district court.
You're moving to dismiss count 1.
Yes, Your Honor.
People being unable to proceed on count 1, that matter, that case is, or that charge is dismissed. I'll continue to defend its not guilty plea as to count 2. Set this matter for pretrial before Judge Barr on
June 18th at 10 a.m. Judge Barr.
June 18, 2025, 10 a.m.
Your Honor, may I address bond?
Now the defence is asking for a bond modification to allow contact for the birth of a child. Emotional appeals like this can work, but the judge isn't budging without confirmation from the complaining witness. This is a high-stakes gamble. If the witness doesn't consent, the defendant stays locked into the no-contact order.
He's out.
Correct. There was a
change.
There is a no contact order between the complaining witness and my client, which, as you know, previously she did provide me with a letter requesting contact. I know she shared the same sentiment with the victim's advocate. She's also due to have their child on the 15th of June, Your Honor. So I would be asking for a change in that bond so that he can have contact and also allow him to be present for the birth of his child.
And Your Honor, according to my notes, we haven't had any contact regarding her wanting consensual contact. The last contact we had with her, she confirmed it was her on the phone and then hung up and then didn't mention anything about contact. So we don't have any knowledge as to whether she want contact from our office.
I keep saying it's every other day. Yeah, they keep. It's like that. It's what?
Gonna help.
It's not. I know it's not. It's like
It's okay. Just let it go. Because if he's not here to say anything, he's not going to change his mind. You're just going to make yourself into hot water.
Anything else, Mr. Elman?
No, Your Honor. Thank you. I just, again, that he would like to be present for the birth of his child.
I understand that, but unless we've heard, and I understand the letter, but I have not heard from her, as I recall it. So your motion for bond modification is denied. Bond will continue with its conditions.
And Your Honor, you said that the case is moving in front of Judge Barr. Did I hear that correctly?
Yes.
Okay. So any emergency bond motion would be in front of him at that time.
I don't know how he handles that, so go for it.
All right. Thank you, Your Honor. Good to see you.
Thank you. Is that right? All right, we're ready on Gatlin. Okay.
Andrew Childers appearing on behalf of the people, Your Honor.
Assistant Public Defender Ben Dennis on behalf of Mr. Gatlin, who stands to my right, and you state your name for the record, sir. My name is Montel Gatlin.
Thank you. All right. 8 times that. Oh, yes, sir.
Hey, John, before we proceed, I would like to just take accountability for what I've done.
The defendant tries to plead guilty on the spot, a bold but risky move. The judge shuts it down immediately because this isn't the right stage for it. Preliminary exams are about testing the prosecution's case, not resolving it. The defendant's eagerness might backfire if it comes across as impulsive or uninformed.
I would like to plead guilty to.
Hold on. No. Mr. Gatlin. No. Hold on a second. Okay, hold on.
There's a process to it, okay? And so I hear what you're saying. You're not discounting it, but this would not be the place to do it, to do that right now. The question would be today, given what you kind of just said, is to whether or not you want to have this preliminary examination.
I would like to hold it, and I would like the court to hear me out. That's it.
So you want to hold your preliminary examination?
Yes, I would like to hold.
Okay. Did you want to speak further with your counsel, given what you just said? And
I would not like to speak further with my counsel. I feel like my counsel
is what? Okay. All right. Okay. I just want to make sure, and I'm doing this because I want to make sure things are fair for you, that you understand this isn't the point at which you would testify typically. You understand that?
Yes.
Okay, that's what I'm trying to. So here's the thing, Mr. Cameron. You said something to me or said something out loud, stopped you, right?
Yes.
Then when I asked whether or not you wanted to have your preliminary examination, you then stated that you want to be heard.
Yes.
Okay. This proceeding, the preliminary examination, not saying it hasn't happened before, but this particular proceeding is not one where you would typically be testifying or saying things to the court.
I would love to if you would give me a chance.
Okay, well, let me do this, okay? Because again, I'm not disputing anything that you may want to do. I just have to make sure that you're not doing something that may jeopardize your rights, okay? So what? Just bear with me. I got to do my job, right? Okay. All right. So I'm hearing you. I think what I'm going to do is I'm going to pass the matter. I'm going to let you just briefly talk with your attorney and maybe the chief deputy of the public defender's office so that process-wise you understand it and understand what typically will happen at this proceeding and what won't happen, or what, strike that, what typically happens at this proceeding and also what typically does not happen. Okay? And I think you may be asking to do something that typically does not happen. And I just want you to be clear on that. Okay?
I'm just trying to plead to all.
Stop. Hold on. I hear you. If that's what you want to do, there's a way maybe to go about doing that.
Okay, I don't think they want to help me. I don't.
Well, hold on. Stan, I hear you. Okay. I'm trying to say it in a way. Here's what I'm going to do. I'm going to pass the matter. We'll find Mr. Brown. I'm going to have you talk to Mr. Brown. All right, with the PD's office, just to make sure you're clear on everything. Because I have to make sure that your rights are protected. Okay. So we're going to do it that way. We're going to do it that way. All right. That may mean you might come back up. We might be in the same boat, but I just have to make sure. Okay. Fair enough. Okay. So let's take him back.
Your Honor, real quick.
Okay.
Yeah, I'm fine.
Take him back. Counsel approach, please.
Defender Defendant, on behalf of Mr. Gatlin, who is entering the courtroom now. Mr. Gatlin, would you state your name for the record, please?
Montel Gatlin.
The defense requests a competency evaluation, and the judge grants it. This is a major turning point. If the defendant is deemed incompetent to stand trial, the entire case could be delayed or even dismissed. The prosecution's frustration is palpable. They were ready to move forward, but now everything's on hold.
Your Honor, at this time, the defense will refer Mr. Gatlin to the Forensic Center for competency. On both cases, I will email the form to the clerk of the court later today.
All right, very good.
Mr. Simpson, what's going on here?
I'm sorry? Well, they've asked for a forensic evaluation. There's not, well, just Gatlin, just hold on a minute. I can't, when it's requested by counsel, there's really not a lot I can do except to do the referral. Okay.
A forensic on what?
Likely for competency and criminal responsibility.
I'm just saying, what is that reason for trying to even do this just because I was trying to say something?
Well,
What's that reason?
no. I don't. Okay, so I'm not privy by design to all of the conversations that you have with counsel. You have conversations with counsel.
And still say what I wanted to say on record.
And I'm gonna tell you something, Mr. Gatlin. That would. I just hold on a second. I don't know that would not only be a wise decision for you to come out and start stating stuff, but would also make me a bit concerned as to whether or not you understand the nature and objects of the proceedings. That is why I stopped it where I did the first time. And you're still in, and you're still in the same spot. And so your counsel has come out, they've asked for that. I'm going to proceed to their request because they've made the request. So set a competency hearing date for
September 9th.
September 9th, 2025, 9 a.m.
Mr.
Simpson, go ahead. Go ahead.
So you telling me they pushing my next court date all the way to September just because I wanted to come in here and take accountability?
No, I don't know. No.
The defendant is frustrated, thinking his attempt to take accountability is being punished with a delayed court date. But the judge's concern is bigger. If the defendant doesn't understand the process, his rights could be at risk. This is the judge's way of saying, slow down, justice isn't about speed, it's about fairness.
I don't think you should look at it that way because the two aren't necessarily connected that way. They're not trying to push your case. The problem, Mr. Gatlin, is you're trying to do things that may not be in your best interest.
It's in my best interest.
No, it is not. That is why that is why I stopped the proceedings when I did. It was clear to me that what you were trying to do was not part of the process and may very well be against your interest to just
Take accountability.
it's clear you don't understand how this works.
I was being charged with some charges, and I was clearly just trying to take accountability for my charges.
And accountability can happen, but it doesn't mean that you load yourself up with everything that's there, which is what you were trying to do. And hold on, hold on. After, when we had Mr. Brown up there and I talked to Mr. Brown and Mr. Childers, Denowith, it's clear that there's an offer of some type.
I don't want to.
There's part of the problem. You're trying to, I'm done. Because you're not listening to me. You're just deciding you want to do something your way. I'm trying to explain to you why I'm doing it this way. I'm done. Bond continue.